next speaker is the Honorable Lloyd Budzinski. Judge Budzinski served as Crown Attorney, Defense Counsel, Assistant Deputy Minister of Criminal Law, and judge with the Ontario Court of Justice for over 50 years, with over 50 years of trial experience. Judge Budzinski has taught across Ontario, currently trains lawyers, investigators, probation officers, teachers, and students on advocacy, basic and advanced evidence, reliable testimony, and bias. Because of my conversations with the Honorable Budzinski, he is actually going to be giving two presentations today. He has a wealth of knowledge to share with us, and his first presentation is entitled Evidence in Legal Investigation. This presentation explores the relevance of evidence as it pertains to the probability of the facts in issue. So I will turn it over to you, Your Honor.
Yeah, can you hear me now? Is my microphone on?
You're good to go. Do you have a PowerPoint presentation, or are you going to talk?
I'm all ready, okay.
Let me just go ahead.
Okay. Well, the first thing is you have available to you my written notes on this. So if I tend to ramble, which I tend to do because I'm somewhat eclectic and get off track, you always have those notes to sort of thoroughly tell you what I'm trying to say. So the whole idea of my approach here is to change the way we teach police officers and anyone in the security field. We do that essentially by focusing on looking at yourself, teaching yourself by looking at yourself and not memorizing rules. So I start off my lectures usually with, what is the single most important question in a courtroom? And everyone pauses and thinks, and the question is, or the answer is, do people believe you? It's not, did you follow procedure? It's not, were you legally justified? Those things matter, but none of them matter if nobody believes you. The first duty of a witness is to be believed. Now, credibility is a bridge between what you did and what justice accepts as true. The bridge is built on how human beings, including judges, perceive the world. And it starts with an experiment. This is not about legal training. This is not a use of force review, nor is it a policy seminar. It is an understanding of the invisible forces that shape how people judge you. And before you say a single word, every person here, security officers, police, transit, bylaw, investigators, if your job puts you in front of the public and possibly a court, this is for you. Every person you will ever deal with is biased, including me. When you understand bias, you stop being its victim and you start using it. I sort of developed this whole theory about the importance of bias and how we filter information by looking at a study at Yale University with babies as early as 3 months old. They would watch a puppet show, and one puppet would help another climb a hill. A second puppet shoved the climber back down. These babies had no language, no education, no law school. And yet, overwhelmingly, they preferred the helper. Even that one study verifies 3 principal truths about human nature. The first is we're tribal. We like people like ourselves. Why your mom says marry someone of the same religion, or you like a person of the same color, you feel more comfortable. That's a natural tendency evolved over centuries to protect us from our enemies. We feel safe when we are familiar with the person we are talking to. We instinctively, rule 2 is dislike bullies. We're empathetic creatures. We don't like bullies, but we will accept a bully who's more like us. So likeness trumps bullying. Now, the third rule from that, which comes from the empathy factor, everyone deserves dignity. Dignity is not earned, it's an entitlement. Respect is something you earn. Dignity is something that everyone is entitled to. So with those 3 rules, we look at how we should deal with people, how we should be an investigator. Now, all of this is to protect us from an unfamiliar threat. Now, the judge has a law degree, decades of experience, a solemn obligation to be fair. Inside their skull, the same hardware that kept our ancestors alive. They will form an impression of you quickly. They will spend the rest of your testimony defending it. If you turn out sour, you're stuck with that. If you turn out nice, you earn it and you have it for the testimony. Now, why is the likeness part important? Well, if you are like the judge, and the judge is an objective person with no point of view in hearing a case, if you are like the judge, an objective witness, you will be like the judge, and you're expected to be objective. As long as that relationship exists, I'm not filtering your evidence. I am believing you, and I have less filters to suspect that you're not believable. But there's another person in that courtroom, the lawyer. Now, what is the lawyer? Is he objective? No, he has a point of view. What kind of people have point of views? Telemarketers, real estate salesmen, car salesmen. That's not to say the lawyer's unethical. He's got a job to do. But what it does mean is, with his point of view, I am filtering his information as you would filter the information of some telemarketer that phones you during supper time. Now, that's important, because why do lawyers like to get the witness mad? Well, think of it. When you're testifying and you're objective, you're telling both sides of the story. You're not involved in that other than repeating what you saw. Once you get angry, you are now naturally, not maliciously, not because you're a bad person, but you're defending yourself. It's a natural tendency of self-defense. Once you start defending yourself, you inherit a point of view. Now, does the judge have a point of view? No. Does the lawyer have a point of view? Yes. That's why when you start arguing with the lawyer, you have now transferred yourself into being an advocate. And now I'm beginning to filter your information much more carefully than I would if you were like me. So that's the principle of likeness, okay? Now, we form these impressions quickly. And once you form an impression, and you do it in 90 seconds, the psychologists tell us, I have a hard time of removing that original that impression from you. Now look how the issue of dignity can be so important, and that 90-second rule can be so important. We don't like bullies. During the G20 conference, there was an officer, the press called him Officer Bubbles. He was a big, tall, 6'7" police officer, weighed about 300 pounds, and a young lady from some press agency, left-wing press agency, was blowing bubbles in his face during the demonstration, and he was providing security. Now, that officer on videotape said to this young lady, "Stop that. I'm going to arrest you if you don't stop that," in a loud, firm voice. Police are taught to use loud, firm voices to show they're in control. The press caught on that, and he became the bully. He was talking down to this little 5'3" woman. She was young. She was blowing bubbles. She was foolish, but he got the rap for being the bully. I asked people in the audience to close their eyes for a moment and imagine the reverse scene. Him standing over this young woman and saying to her, instead of "Stop that immediately or I'm going to arrest you," if he said to her, "Madam," gave her a title, "Please," gave her a courtesy, "Stop that now. You're interfering with my job. Please." He gave her an explanation, gave her an identity, gave her a courtesy, and gave her an explanation. Who is the bully in that scene? He is the underdog. She is the bully. So I try to teach officers that it's okay to be the underdog. Nothing wrong with being the person who we want to draw empathy to. And you think of it. You are more considerate of a person who you have empathy for. The young girl who's stuck in a well in Texas. You feel sorry for her. You want to help her. That's why in many cases, young women giving evidence, or any young officer giving evidence in the stand, and is getting confused but being nice and courteous, the judge's sympathy or the jury's sympathy will favor her. doesn't mean that we trust you more, believe you more. It just means we're doing less filtering of your information. We accept it more. So that 90-second rule and being a bully can destroy your believability. Now, you are the most powerful person in that world. You enforce the law. You represent a client, Hudson's Bay, for example. Now, my experience shows me that if you mess up in the stand, the media, it doesn't say security agency AYZ messed up. They say Hudson's Bay messed up. So you carry your client's image. And if I were marketing my product as a security firm, I'm arguing that if I represent you, the Bay, you'll be proud of the Bay image because I'll maintain the Bay image. But for that, you have to be respected and you have to be concerned about the people you're dealing with. You represent not only the client, but you represent the society and you represent the administration of justice and the charter. And within that, you represent both the client and the accused and the administration of justice. And that's what the charter speaks about, and that's what's expected from you. Now, you have three duties. You have your duty to your client, like I said, the duty to the citizens whose rights you affect, and the duty to the administration of justice. You have to honor all three, and you become extraordinarily credible if you can maintain that. Now, you see what I'm doing? I'm not teaching a bunch of rules. I'm just talking to people to think about how they think about things. It's like self-analysis. It's a psychology of looking at yourself and seeing how you feel. Just think of this. Remember when you go to Air Canada and you got the best vacation in the world planned, and you walk up to the desk and they tell you your plane's been canceled, but they won't tell you why. How do you feel inside? You're angry, you're frustrated, you want to scream. Think of arresting a person. You put the handcuffs on him, or you try to detain him, but you don't give him an explanation why you're doing it, or you don't allow him to explain. If you want to reduce resistance, 3 rules. Treat that person with dignity. Give him a name. B, give him a courtesy, please. And say, as soon as I get these handcuffs on you, I'm not telling you how to deal with the security system. You got to time yourself on what's right and what's wrong at that time. But to say to that person, essentially, that I'll give you a chance to explain. And that's important too, because it now falls into objectivity. People, young officers, start off with the premise they have to prove the guilt. Not true. The accused is entitled to an explanation. You look at that explanation, you encourage the explanation, but you don't suppress it and try to get him to confess. Let him explain any way he wants. Then you go out and try to verify his explanation. That's reverse onus to deal with confirmation bias. So by proving he's telling the truth, you've solved your problem and you've let a person who could be wrongly convicted free. If you can't prove his explanation, you have a powerful tool called consciousness of guilt. If you can prove that he's lying outside the stand, then, of course, you have the ability now to provide consciousness of guilt, which is evidence upon which a conviction can be based in a circumstantial case. The other sort of thing issue I teach about in the issue of objectivity is the issue of the question, isn't it possible? Now, everyone hates that question because everyone's got to answer, yes, it's possible, when the lawyer gives you a different explanation. But that's not the way you answer that question. That's an opinion question, and you have to understand that that's an opinion question. Generally, you're not allowed to give opinions. But in this case, when the lawyer asks it, you look at the judge and say, can I give my opinion? That's what he's asking. You never try to trap the lawyer in a trick. You always ask the judge's permission to advance your explanation of whatever you're saying. The answer to that is you say, well, sir, I've examined all elements of this case. I've looked at A, B, and C, and I accept it for the following reasons. I reject explanation B for the following reasons. Having looked at A, B, C, and E, good and bad, you got to understand both of them. You now say, based on my observations and my evaluation of the facts, in my opinion, because it's an opinion, not an observation, it's not possible. So my method of teaching is to teach the student or the young officer, because it's a fallacy, it's a problem both in police forces and in security systems, that if you're treat people with dignity, if you are empathetic or you're the least bully, and if you are objective, you're believable. And that's what the public expects. That's what your client expects. And in that way, we get better policing. Now, fairness, just to finish off, fairness is two things together. Dignity is how we treat people. Respect, you have to earn respect. You don't have to respect the person you're dealing with, but you owe that person dignity. Objectivity is how you gather evidence. You remove either one of them, and it's not fairness. If you have both of them, dignity and objectivity, that's fairness. That's what the judge is. That's what the judge looks for. And if you're like the judge, you will have less filters on your evidence. So you see, there's no rules here. It's just simply common sense, looking at how we think about things and assessing ourselves how we feel in such a situation. Being polite and biased is not fair because you're biased. Being thorough and contemptuous is not fair because you're contemptuous. Both are needed together. Every gap in your fairness is a gap in your credibility. Now, I've pretty well covered in short form what my written notes were, and I'm always more comfortable in a seminar situation. So if you want to stop now, Roy, we can go into a question time if I have any time left. Do you want to do that, or?
We can absolutely do that. No problem. Yeah, you have time left if you want to add any more comments you want to make, but we actually are going to be missing another speaker, so there is a lot of flexibility in time. If anyone does have any questions, if you want to talk for another 2 or 3 minutes, then we can get another 5 minutes of questions, if you have anything more to add.
Okay.
If not, we can go into questions, because I'm sure there's going to be questions.
Okay, so going back to objectivity, it's incumbent that every investigator learns that they represent the client, that they are not sort of onto themselves, and their reputation will reflect on the firm, but in the courtroom and the public's eye, like I said earlier, it's the Hudson's Bay Company testifying and not AYZ security firm. And there's a lot of disdain among Crown attorneys and prosecutors when these independent security people come forward to give evidence, because they don't talk the police language. They're highly motivated by protecting their own interest. And the item that I have to sort of force onto people, I'm repeating myself, is you got to be the empathetic person. You can't be the bully. You got to be objective as possible. And that improves the reputation of your company as much as the client that you're acting for. Now, in doing that, it's in reverse onus. When I did a case called Kelly, an RCMP officer who threw his wife off the balcony at the Palace Pier, he gave an explanation how he tried to run from the kitchen to save her because she was bouncing on a stool trying to fix a rattle on the part of the balcony above her, and she was right on the edge. And he said, as I ran up to her, she slipped through my arms and I wasn't able to hold her. We were face to face for a moment. She was standing on the stool. Now, I knew with my background, maths and physics, that if her rear end was above the railing, she would topple over, that he'd be grabbing her feet if he could run that distance in that period of time from the kitchen to the balcony. So when we sent it to the Center of Forensic Science to do a study of that to see how true his story was, my instructions to the center were, don't prove Kelly was lying. try to show me that he was telling the truth. Now that's a reverse onus situation, and it deals away with confirmation bias. What they did, of course, they were unable to have any runner, even the fastest runner, even in the most path that was had least amount of obstacles, they were able to show that no one could do it. So in investigation, it's not always trying to get your man. It's trying to show that maybe he is innocent. That changes the whole complexion of attitude, how you're viewed by the public, by the judge, by the jury. And that's so important because it shows that empathy and that understanding. And it's that approach which I'm trying to get across to young lawyers and police officers and security people when I lecture, is that it's based on a lot of your objectivity, your reliability, and your believable. And that's what the public want in the justice system. And that's what I'm trying to sell or market here, is teaching not rules, but understanding public expectations and how to play to those or feed those public expectations. So it improves policing, it improves teaching, and it's a simpler way of, rather than lecturing on a whole bunch of rules. I start, deal with another topic. Motive, supporting evidence. This is a little bit of my later lecture, but officers don't understand that. They just think they grab the person, they see them taking something, and that's it. But in a domestic dispute, I have to be able to say, or any kind of dispute, why on a one-on-one case where you have the accused testifying, but I don't believe the accused, but the person I do believe, I've got to be able to articulate the reasons why I believe. And the investigator has to get me that evidence to show why I should believe that person. Rejecting the accused evidence in the stand does not create evidence of guilt. I can't use his lying in the stand as evidence of guilt. I can use his lying outside the stand, outside the courtroom, as evidence of guilt if proven to be a lie, but not his lying in the stand. So I have to find the words to describe why I think the one witness for the Crown or for your client is telling the truth. And for that, the collection of supportive evidence, the narrative, the surrounding evidence, is really part of that case. But I can deal with that later on in my second lecture. Any questions now?
Thank you very much, Your Honor. That was very enlightening. Yes, and I will open the floor up to questions. Does anyone wish to start?